Good morning, everyone. It's very nice and a great honor to be here. I will indeed just hopefully that does not. Okay, let's flip over. I'd like to tell you about 3 different new cases that have come out over the last year, basically from the European Court of Justice on insolvency, as you suggested. Family law and all of that is not my major, to be honest. So insolvency law is the thing we're going to talk about. There's a first case you might have heard about, Galapagos. And now you can check whether or not you would have registered and recognized this on a map somewhere. We are talking about a case that is a company called Galapagos registered in Luxembourg. But at first, before I start with that, I want to remind you of a case that is really, really old. And it's actually one of the first judgments from the European Court of Justice on insolvency, Susanne Staubitz-Schreiber. And that is a case that comes up now and then. It was a German debtor who ran out of business and who filed for insolvency in the local court in Wuppertal, and later on moved to Spain, apparently, because when you look at this letter here, this is a good move. And the local court in Wuppertal thought whether or not they actually remain and gain jurisdiction over this case, and first decided against it and said, well, now she's in Spain and we do not have to take care about her anymore. This has gone up to the European Court of Justice, and the European Court of Justice at that time said, during the time she filed for insolvency, she lived in Wuppertal, and that's why the court in Wuppertal remained to be competent, and please, court in Wuppertal, take care of her. And it actually ruled that the court of the member state within the territory of which the debtor has the center of main interest when filed for opening retains jurisdiction to decide on the opening, even if the debtor transfers its comi to a different member state later on. This case law has been repeated, or it has been sort of reconfirmed multiple times from the European Court of Justice, and it plays still today quite a role. So one side note on this, you might have noticed that the European Insolvency Regulation has got into force on May 2002. This case was before the court in Wuppertal before that, actually in April, but there is a transition note, and it says if there's no opening decision prior to getting the European Insolvency Regulation into force, that would apply. So that's why we have this case. Galapagos, not the one somewhere in the ocean, but a company registered in Luxembourg, and it moved its comi to the UK in June 19. The company's directors filed petition to open insolvency proceedings in the UK in August, but creditors were not terribly happy about that, and basically pressured the company and the shareholder to replace directors the next day, and tried to hire lawyers to withdraw the petition. That didn't work out because other creditors joined the party, and then new directors were put into place who moved again the comi to Düsseldorf in Germany, and instructed new lawyers to file petition to open insolvency proceedings in Düsseldorf. The court in Düsseldorf said, oh, wait a second, this is not going to happen here, and first appointed preliminary insolvency administrator to check what's going on. On appeal, the appeal court said, no way, this is not going to work, but another creditor joined the party again and also filed petition in Düsseldorf. And then the court in Düsseldorf accepted this petition in August 2019 and appointed the same preliminary insolvency administrator and said, well, now comi is in Düsseldorf, like 2 days after London however this is going to work. And then the subsidiary of that company filed an appeal, and it ended up with the Federal Court of Justice in Germany, which said, European Court of Justice, please help us whether or not Düsseldorf has jurisdiction over this or not. And the European Court of Justice was addressed with various questions. One was whether the new insolvency regulation still means the same in terms of the timing of filing is decisive or not. And the European Court of Justice said there's no difference. And actually, if you look at the reasoning, if you look at the recitals of the new European Insolvency Regulation, there was no real question about whether or not there would be any change. There's not. And the European Court of Justice did say that the court of the member state retains exclusive jurisdiction to open main proceedings when the COMI has moved to another member state after the petition, until it made its final decision, which means that the court in the member state receiving the later petition is actually blocked until there is a dismissing decision by the first court. This in itself is not terribly new, or this is not really rocket science and groundbreaking notes. I mean, if you look at the Staubitz-Schreiber case from 2006, what else could there be as this decision? It did make a very small note about form shopping and said that the transfer of a jurisdiction should not hinder the effectiveness of the regulation and the effectiveness of cross-border proceedings. There was another note in this decision, and I think this is actually more interesting than the actual question whether or not London or Düsseldorf had COMI at the time. And this is the note on Brexit, because the Court of Justice said that the European insolvency application is only applicable in case the main proceedings were opened prior to the end of the transition period. And only if that happens, then the UK and Germany could rely on Article 3 and the blocking mechanism and the blocking effects of that provision. And it also made a note to say that insolvency practitioners from the UK seeking recognition of UK proceedings in other European member states now, after the transition period, need to seek recognition on the national insolvency laws or national civil procedure laws, or whatever is applicable and available in these various countries, or open parallel proceedings over there. So that was in March 2020, and so it was way beyond the transition period. So it does, well, have a weird timing. This judgment came back to the Federal Court of Justice in Germany, which had placed the questions to the European Court and get now the answers, reiterating that the blocking effective of Article 3 would, in theory, have blocked Germany, but because the court in the High Court in England did not open insolvency proceedings in England prior to the end of the transition period, the European court, the German court in Düsseldorf was no longer blocked and could indeed obtain jurisdiction and competence over these proceedings. And this was just established, and it said, yeah, well, now UK doesn't count anymore, UK doesn't matter anymore. And so we open proceedings here because England was basically too late, which is an interesting question also because the German autonomous international insolvency laws are pretty much copy-paste of the European insolvency regulation. It's much shorter, it's much more concise and compact, but the mechanism is the same. It's an automatic recognition of foreign proceedings. It's the application of the Lex Foreign Concursus. It gains all the exceptions for employees, etc. So it's very much copy-paste, and in the reasoning from the German legislator at the time, it said that the European Insolvency Regulation should serve as an interpretation assist. But here the German court said that the German insolvency laws on international insolvency proceedings does not contain a provision to actually block the opening of insolvency proceedings in Germany because there's an opening in another one. It rather said that the German law does not contain the same logic, however this comes from now, and said just because there's a petition pending in the UK, too bad, it does not block the German court from opening the proceedings, even though the English one would have been recognized later on in Germany. So that's an interesting move by the German court that we'll see what's going to happen with that, because it's well, departing from the logic that European Insolvency Regulation serves as an interpretation assistance to us. So this is the first case I like to tell you. The second one is a triangle case. The case is called Öltrans. And it's a case where two companies, Öltrans and Tankfracht, this is a bit of a tongue twister that we're going to do it now. Anyway, so it's two German companies that belong to the Öltrans group. And they, Tankfracht and the Dutch company E.E. Frerichs, I'm going to break my tongue over this case, entered into a contract under Dutch law on a vessel. This is not really relevant, but the Tankfracht company owed E.E. Frerichs about 8,000 euros. Not a big thing. Anyway, in November 2010, Öltrans paid, instead of Tankfracht, to Frerichs this 8,000 euros. Öltrans filed for insolvency a couple of months, or just right afterwards, and then in April, 3 months later after the filing, end of April, proceedings were opened for Öltrans in Germany. And as German insolvency administrators do, they keep the insolvency issues until the very end. And so the German insolvency administrator filed an avoidance action in December 14 against Frerichs to say, we paid you that amount, we didn't owe you, so please just pay it back. The question was certainly what laws apply, and Gregory has taught us yesterday a lot about legal acts and what is, whether a payment falls under this, whether the payment is governed by German law because it came out of a German bank account, or whether it actually is stuck to the contract that was under Dutch law. E.E. Frerichs refused because it said, too bad. Period of limitation has passed already. The first instance in Germany, you could say, of course, ruled in favor of the German administrator. It got dismissed by the appeal court. It ended up with the German court and ended up with the European Court of Justice, as all these cases do. The European Court of Justice said, number one, lex fori concursus determines avoidance powers that we heard yesterday. It also referred to the Article 13, which is now 16, on the lex causa objection, and it referred to Article 12 of Rome, which actually just says that the law applicable to the contract is also applicable to the performance of the obligation created by it. So you could ask, why do we talk about this? But here we have a third party paying, and the question at least arose whether Article 12 is also applicable for payments by third parties. But the European Court of Justice said, yes, the law applicable to the contract also governs the payment made by a third party, even though, because the law governing the contract and governing the payment continues to governing this transaction overall, also beyond the opening of insolvency proceedings. The purpose of Article 13, now 16, is that the person benefiting from the voided transaction can rely on the governing law that had been, can rely on the law governing the transaction at the time, beyond the insolvency, beyond the opening of the insolvency proceedings, and that the party who received the payment may also assume that the law applicable to the contract also is applicable on the payment, even made by a third party. And so, because the contract was under Dutch law, the payment by a third party was under Dutch law, and so Article 13, Lex Causa, Dutch statute of limitation was applicable. And because German insolvency administrators are always too late with their insolvency avoidance transaction, that was actually already time barred at the time the lawsuit was filed. Just one side note, the German statute of limitation is typically in civil law cases 3 years from the end of the year in which the claim arises, plus 3 years. So you have a claim arising in April, like here, because of the opening of the insolvency proceedings. The limitation period starts in December that year, or by 31st of December that year, plus 3 years. And this is why the avoidance cases are always pushed to the end of insolvency proceedings in Germany. And that's why they're always too late with these cross-border cases, because pretty much any other jurisdiction has shorter limitation periods than we have. The last case I want to touch on briefly, and then I might actually need very quickly Jessica's help, is a case Alpinebau. It's a Austrian case. Alpinebau, you may have heard about this, where insolvency proceedings, main insolvency proceedings were opened in Vienna in Austria, and secondary proceedings over the branch with the court in Slovenia in, now you need to help me, please. Celje. Okay, that's the one. And the creditors and the liquidators were informed about the right to lodge their claims in the secondary proceedings in Celje within a very short time period of 3 months. The court also warned that claims that were not filed in time would actually be extinguished, and the liquidator of Alpinebau in Austria applied or sent all these cases to the secondary insolvency administrator 2 months after that deadline, and it was rejected because too late. It ended up with the European Court of Justice, and the European Court of Justice said, well, look at Article 32, the old one, and it actually is to be interpreted to say that main insolvency administrators shall lodge the bulk of claims they have received in their main proceedings from their creditors altogether in the secondary proceedings, however, subject to the laws of the secondary proceedings and including all these time limitations, including the consequences for not filing on time. And the main insolvency administrator does not have to wait for any verification or any admission of the claims in the main proceedings. He does not have to examine the course of action and everything that you would do. He just needs to take the bulk of the cases or bulk of the claims and file these in the secondary proceedings. They would be verified and admitted under the laws of the secondary proceedings by the administrator of the secondary proceedings, and it would be governed by that law of the secondary proceedings. Who knew? It also said that the Article 32 of the old insolvency regulation is pretty much the same as the new ones. There is one addition, though, in the new insolvency regulation in Article 55, and it now has a time, well, sort of a minimum time applied now that says that for foreign creditors, you actually would have to allow a time period of 30 days to lodge their claims, because apparently for foreign creditors, it's usually a lot more burdensome and more difficult to file. But the crack with that case is that often, and I'm not entirely sure about the Austrian case, and I don't think there's somebody from Austria here. Also that in Germany, it would be the case that there is no harsh deadline on filing insolvency claims. Creditors can file their claims until the very end of the proceedings, until the very last final creditors list is made up, and until the just pretty much a few days before the actual distribution is made, to be honest. This means that often and administrators get claims years after the proceedings have been commenced. But when you have secondary proceedings and the main administrators needs to take all these claims and file them in time within the time limits of the secondary proceedings, that often clashes. That's certainly a question how this can be done in reality, because there need to be a lot of information around this, and the probably main administrators also need to take care of his or her creditors and allow them probably in addition to what's necessary, and tell them, main administrator need to file everything into the secondary proceedings, and they have a very, very short time period, and get me your claims right now, because otherwise they will be dismissed. So that's a bit of a clash apparently we see, and this apparently happened here as well. So these would be the cases I'd like to I'd like to tell you, and then I'm certainly open and happy to ask any questions, answer any questions.